Hello, everyone, and thank you for joining us today. My name is Kristen McMahon, and I have the privilege of serving as the president of the Robert H. Jackson Center in Jamestown, New York. Today, we are delighted to bring you this conversation more than 3 years in the making called Designing Justice, the New Tribunal for Ukraine and Beyond. Before I introduce our guests for this conversation, a few housekeeping notes. This webinar is being recorded and will be made available to the public. Automated captions are enabled, so if you need those, please turn on that feature to enhance your experience. And there will be a Q&A portion at the end of our conversation, but you do not need to wait until then to ask your questions. Please feel free to put your questions in the Q&A section as you think of them. Our panel today has been working tirelessly on justice mechanisms writ large for most of their careers, and specifically for our conversation today, have been deeply involved with standing up a special tribunal for the crime of aggression for Ukraine. This work actually fits very neatly into the Jackson Center's programming theme for 2025, which is accountability, the role we have. And so I am pleased to introduce for our panel today David Crane, the founding Chief Prosecutor for the Special Court for Sierra Leone and the founder of the Global Accountability Network; Ambassador Hans Corell, former Undersecretary General for Legal Affairs and the Legal Counsel of the United Nations; Ina Liniova, Director of the Human Rights Institute of the Ukrainian Bar Association; and the Honorable Erwin Kotler, International Chair of the Raoul Wallenberg Center for Human Rights, an emeritus professor of law at McGill University, Minister of Justice and Attorney General of Canada, as well as all of you being international human rights lawyers as well. Thank you so very much for joining us today for this conversation. I thought it might make sense, since you all have been working on this sort of behind the scenes as far as the public is concerned on this, that it would be good to sort of start at the beginning. And David, I'm going to start with you to get a sense of the formation of the tribunal. Why this particular structure? And then we can talk about maybe some of the challenges that have arisen in standing this up.
Well, thank you. And it's a real pleasure to be here to talk to you this afternoon, perhaps this evening, and to kind of highlight, I think, a special moment in international criminal law, and that is the creation of another tribunal to seek justice for the people of Ukraine. It's interesting, the people on this panel, particularly Erwin and Hans and I and others, were instrumental in really creating the whole structure of what we're doing today. But we've also have to understand that it's kind of a given that the international community does not like to set up tribunals. They will do it, but it'll be a political decision. And so a lot of our work over these past 3 years, and we came together, the four of us, along with David Sheffer and Richard Goldstone, in June of 2022, we created a high-level working group to advise the United Nations and eventually the core group in Europe on the creation of some type of tribunal to deal with the tragedy of aggression that the Russian Federation has perpetrated against Ukraine. And so we're all colleagues and friends. We've been doing this for decades. And so I just called this esteemed group and said, look, we need to start talking about what do we do about aggression, since you may or may not know the International Criminal Court does not have jurisdiction over this particular act of aggression. And so we have to set up a different system other than the International Criminal Court, even though the International Criminal Court does have jurisdiction over other international crimes and has done so. But so we had to figure out a way by which we could get, at the time, the UN General Assembly to begin talking about setting up a special tribunal. So this group of myself, Hans Corell, Erwin Kotler, David Sheffer, Richard Goldstone, and then we wanted a representative from the Ukraine Bar Association, and Ina readily joined us. And so we've been working on advising and putting together this tribunal. So it began in June of 2022, and here we are now in July of 2025 with a model that could work. It wasn't the initial thought process that we offered to the UN General Assembly and the core group over time, but in many ways it is workable. And the alternative is nothing. And so to finish up my comments real quickly, is it's a political, international criminal tribunals are created in a political environment. The bright red thread of creating a tribunal is politics. It's a political decision, not a legal one, and there are many political compromises that go with the creation of a tribunal. And so, like all of the rest that those of us that have been involved in this for decades, it again was a political compromise that allowed us to create a justice mechanism on aggression for the people of Ukraine.
Hans, I wonder if you could help us understand. David mentioned some of the changes and some of the challenges. The international community does not particularly love these kind of tribunals. So can you talk about some of the barriers that had to be overcome to actually get this created?
Well, I mean, I'm very sad that the proposal that we put forward was not accepted. When I was a legal counsel of the United Nations, involved in the establishment of all the international criminal tribunals that there are around the world, or were around the world today, except the one in Kosovo and East Timor. But when I was Kofi Annan's representative at the Rome conference, when we negotiated the treaty that established the International Criminal Court, that's based in The Hague. But I had hoped very much that what should be established for Ukraine would be modeled after the Special Court of Sierra Leone, where David Crane was the first chief prosecutor. Why? Because that was an excellent court, and before that court, a head of state was tried. And this is one of the very important element here if you establish a tribunal for the Ukraine. But I was also involved in establishing not only the court in Sierra Leone, but also the chambers, the extraordinary chambers in the courts of Cambodia. In Cambodia, they turned to the General Assembly, while Sierra Leone turned to the Security Council. But Ukraine cannot turn to the Security Council for the simple reason that there will be a Russian veto against this. So I'd hope for a method like Cambodia, turn to the General Assembly, and then the model should be the Special Court for Sierra Leone. And I'd hoped then when this was discussed in the core group in the General Assembly, that this was come forward, but obviously they weren't able to agree. So the core group didn't come to a conclusion that a court of the kind we had proposed should be established, and therefore Ukraine took the step to, shall we say, approach the Council of Europe to establish this tribunal based on an agreement between Ukraine and the Council of Europe. And this is where we stand today.
That's great. Thank you. And Nina, I think that leads in nicely to, obviously since the Russian Federation invaded Ukraine in February of 2022, the geopolitical situation across the globe has really shifted. How have some of those changing in priorities impacted this work?
Thank you, Kristen. It's an excellent question, and I would put it this way. On the one hand, 3 years of the war led to distracting attention of the world from Ukraine because of other conflict. We have the situation with Israel and Gaza, Sudan, and other numerous conflicts in the world that disturb the international peace and justice. So unfortunately, on the one hand, we saw that international community, international organizations, they have plenty to deal with, and it's not Ukraine only now. So the attention was refocused, and Ukraine became less of a priority. I honestly would like to say. However, on the other hand, we see the trend that the longer the war continues, the more committed international community gets, the stricter measures are being applied. And that's the case with the tribunal as well. If in the first days of the full-fledged invasions, the mere thought of the tribunal sounded like a very unrealistic and very idealistic expectation, and now it is a priority. It is the reality in Ukraine. It's been established. It's only on the paper now, but the tribunal exists. It's not a fantasy anymore. So this is a good trend, and I would like to believe that it continues, in a sense that the longer the war continues, the more committed international community gets. I would also like to mention that today is a very it's a fantastic day, honestly, to discuss accountability in Ukraine, because we hear the news that today the European Court of Human Rights delivered an unprecedented judgment in the interstate case of Ukraine versus Russia, where it recognized numerous violations of human rights by the Russian Federation since 2014 and in the course of the full-scale invasion. So this is another step. Together with the establishment of the tribunal, we see that the international system of justice and security responds to the aggression better, and we cannot but welcome such a development, and obviously look forward to the tribunal starting its operation. At the same time, as Professor Crane and other experts mentioned on numerous occasions, the more time passes, the less time we have for the successful accountability, to make successful accountability happen. And we are looking forward to a speedy start of the functioning by the tribunal.
Kristen,
And yes, David, please.
no, just real quickly, time and distraction are Vladimir Putin's ultimate weapons. He is going to try to, he is hanging on by his fingernails in a situation that is now out of his control, but yet he knows us better than we know ourselves in some ways, and that time and distraction, he realizes as long as he hangs on, perhaps the world will become distracted and move on beyond Ukraine. And that almost happened in 2023 in the tragedy in October, where the Hamas attacked Israel. That Ukraine literally fell off the front page. It was no longer even a discussion, and also made us have to reassess how we were going to approach creating that tribunal. And we thought about a more of a European-centric, where countries, member states of the UN could come together very much like Nuremberg and create their own tribunal. So, but yeah, time and distraction is a huge problem. And it'll always be a problem. And so we have to kind of keep focused and on the prize, so to speak, and that is justice for the people of Ukraine. But Ina brings up an excellent point related to that.
Yeah,
If I may,
please, Hans,
add
yes.
just one thing here, that Ina's intervention was very important, what they are doing and how they are thinking in Ukraine. There is actually an excellent presentation by Ambassador Anton Kornievich that was broadcast only a few days ago. And I hope that if you haven't already sent the link to the participant in this session, you should send the link to that presentation, because it was very detailed on how they were reasoning in Ukraine. Thank you.
Thank you, Hans. Yes, we will attach that to this recording as well, so they can find that link with ease. Erwin, I wonder if you could share with us, we talk about, obviously we've been talking about the crime of aggression needed to be stood up, a tribunal for it needed to be stood up separately from the war crimes and crimes against peace. Can you talk about what makes prosecuting a crime of aggression different from prosecuting war crimes and crimes against peace and crimes against humanity for our audience, please?
Well, when we talk about the crime of aggression, we're talking about the supreme crime, what I call the crime of crimes, and it's a leadership crime. And we're talking about individual criminal responsibility at the highest level. And this is important because we want, in particular, not only to secure accountability, and I want to commend you, Kristen, you and the Jackson Center, making the issue of accountability a centerpiece of your work, as well as for organizing this panel. But in the context of accountability, first and foremost, is to combat the culture of impunity. And here, in this regard, Putin has been the epicenter of what the culture of impunity has been all about. In fact, his aggression has been incentivized by the impunity that he's enjoyed. We should not forget that the 21st century began with Putin's invasion of Chechnya, then on to Georgia, and following that onto the Crimea. And in each instance, he was able to continue and have not only his aggression go unaccountable, but in fact incentivize the next aggression. And so his calculation was, well, if I went into Chechnya and Georgia and the Crimea and nothing happened, why should anybody care if I go into Ukraine? It's not an independent country. They're not an independent people. It's all part of Russia. And so this was his calculation. What he miscalculated was the courage of the people of Ukraine. And what he miscalculated was, in fact, the very independence and territorial integrity of the people of Ukraine that he had miscalculated. And I want to pay tribute there to Ina and to Ambassador Kornevich, as was mentioned, of their role in the establishment of this tribunal. I remember David Crane always saying that 2025 has to be the year. And it turned out to be the year, and he and Hans and the Ukrainians played a crucial role in all this. But I think the important point here is the basic foundational principles here to combat a leadership crime, the crime of crimes, to combat the culture of impunity, to pursue justice for the victims and accountability for the human rights violators, and to secure thereby the foundational principles of the UN Charter on the occasion of its 80th anniversary. So this is a timely and important moment.
Thank you. Thank you. I also want to, just in case there are people watching this who are new to our world too, I'm going to attempt to explain what I think is part of this rationale as well. And by all means, correct me if I go astray. So my recollection is, because the crime of aggression was added in the Rome Statute later, that the signatories to the Rome Statute had to also sort of re-sign for that particular element, and that the Russian Federation is not a signatory to the Rome Statute. So absent that, the traditional way that the crime of aggression had been prosecuted was for the Security Council to refer it to the United Nations body to approve that. And since the Russian Federation has a permanent seat on the Security Council, that path was also foreclosed. Am I correct so far?
Yes.
Yeah.
Okay, great. Okay, good. And I always like to sort of make sure we level set too for people who may just be joining this conversation now. So David, then, as far as I know, the only prosecutor who has experience prosecuting as sitting head of state, how is this tribunal addressing that in this instance?
Well, at the end of the day, head of state immunity was kind of the rock in the middle of the stream. It was a challenge. It was the anchor by which the G7 were kind of saying, no, we're not going to do this because we're not going to take on Putin in a justice mechanism to prosecute him before the world while he is a sitting head of state, even though the jurisprudence now is that if a sitting head of state commits international crimes while a head of state immunity does not apply. And this head of state immunity is a rock solid 5 centuries long kind of legal concept, which protects heads of state in their jobs, so to speak, or it goes all the way back to the king can do no wrong. I don't want to go too much into a law lecture, but so that's a challenge. So really, as we work through this from June of 2022 to today, head of state immunities was a real challenge. And this time last year, we were stuck. The G7 was not going to go any farther if they were going to keep pushing. And there was a large member of the core group working with the Council of Europe that insisted that we had the ability, and it's in the statute that the high-level working group, many members of which are in front of you, had advocated. And it was in the statute, which was adjusted out of it. But again, that's the political compromise, isn't that how do we in fact move this forward without throwing the baby out with the bathwater, so to speak? And so within the political compromise is this: we can prosecute people who were part of committing aggression against Ukraine. That's a fact. We cannot, while Putin and his troika is in office, we cannot actually put them on the dock. But the key is that we can indict those individuals, and we can prosecute others who perpetrated the aggression. Senior level members perpetrated the aggression against Ukraine. So justice will start. Justice will be done. There are provisions in the statute that has been approved for trials in absentia, which I'm not a personal advocate of, but it is a tool by which a prosecutor can seek justice for the people of Ukraine. But we can indict Vladimir Putin. We can indict the Minister of Defense. We can indict the Minister of Foreign Affairs and show to the world what they have done. The political victory here right now is just that, and that is the indictment. That will proceed forward once the Special Tribunal gets up and running. That will move forward. And another provision, and it's an important footnote, Vladimir Putin couldn't sustain the military operations that he is currently perpetrating against Ukraine without the help of other countries, Iran, North Korea, somewhat China. And so there is room to, in fact, investigate and perhaps indict 3 sitting heads of state for aiding and abetting aggression. And this is a cutting edge area of international criminal law. It's never been done before, but it's a valid charge, and one that a prosecutor will have the capacity to act as well. So anyway, this is a doable tribunal. This will start the process by which accountability will happen. And Vladimir Putin knows this, and this will just be tightening the screws. He's already has an arrest warrant for him related to crimes against humanity and war crimes dealing with abduction of Ukrainian children. He can't travel. Technically, he does not travel very much. He's afraid he may be detained. And to have the special tribunal within the next year or so issue an indictment against him for aggression, that puts him more and more into a much closer box by which he can operate as a sitting head of state, and will bring tremendous political pressure internally on him to the Russian people, may in fact start asking questions.
I'm curious as to, and Erwin, I think I'm going to start with you on this question. I'm curious as to what are the next steps in terms of this tribunal actually beginning its work? Where are we in that process, and where do we see the perhaps indictments coming out? And I recognize all of this is a little bit squishy in terms of timing, but just to get a sense of how does it forward?
Well, it's an important question, and I'm glad that I'm following David Crane, because I think one of the most important things that this tribunal, if not the most important thing, can do is who the special prosecutor is. I say that because you have to have somebody with the repository of experience and expertise beginning as a special prosecutor. And it takes somebody like David Crane, who's done this, who successfully prosecuted a head of state, who knows how to prepare the prosecution, the indictment, the investigation. As I say, it has a repository of experience and expertise, because if we have the wrong prosecutor, it will all get off on the wrong foot. And that has to do with, in terms of the court, to have the proper judges as well. Here too, we need not only judges with the proper repository of experience and expertise, but one of the critiques has been that this whole process has been Euro-centered. It was brought about because, and to their credit, of the initiatives of the European Parliament, the European Union, the Council of Europe, Parliamentary Assembly, etc., etc. It was very much a European-centered process, along with the core group, which was also yours. So we need an international tribunal that is inclusive and representative in that regard, and where we can invite in more states into the process. It may be an agreement between Ukraine and the Council of Europe, but it's an agreement that's open for participation of others. So again, we need an international judicial group that is experienced with the expertise, but also with the representation. And the other functionaries of the court, the registrar is important that has a proper public defender, a proper defense system for the rights of victims, that it has built in a claims commission, a compensation mechanism. So there's a lot of things that are involved in the establishment, but the crucial thing is to have the right people, and beginning with, as I say, the special prosecutor. And I'm working strongly that David Crane be that person. I say that because if he is the special prosecutor, the court will get off to the right start and everything else will follow. If we don't have the right special prosecutor, we'll get off on the wrong foot and we'll have problems down the line.
Well, I guess that leads me to a nuts and bolts question. Yes, and Hans, yours, and maybe you can answer this as well, is who chooses this, sort of in terms of how we move forward, what are the nuts and bolts for how this goes?
Well, I mean, first of all, I agree with what David Crane and Owen Kotler had said here. And I was also a bit concerned about a trial in absentia. But I realized that it is possible to have a trial in absentia, because the moment a person who might be indicted or even passed a judgment over, once that person is arrested and get hold of this person, you can hold the trial again, start afresh. So you have a trial when the indicted person is present. And I think that is a very important element here. And I would also like to add another element here. What we see here is that a permanent member of the UN Security Council has flagrantly violated the most fundamental rule in this Charter of the United Nations. And this is by a permanent member, and the Security Council has the primary responsibility for the maintenance of international peace and security in the UN system. Now here we have a violation of the famous Article 2, Paragraph 4, that forbids states to threaten or to attack other states. And this is what had happened with Ukraine. So I think it's extremely serious. And that is why it's so important that the world now demonstrates that this cannot be accepted for the future. And therefore, a trial has to be before a court. It's extremely important. Thank you.
Thank you, Hans. Ina, yes.
I just wanted to add that in terms of the procedure, what we see from the statute is that all key vacancies, positions within the court are to be filled by the management committee, which is I am very sorry, which is something like the Assembly of State Parties for the ICC. So the countries that endorse the tribunal form the management committee, and this management committee becomes the factually the governing body. And we're very much looking forward to the formation of the management committee. And it would be also interesting to see which countries will join, because it's not only Council of Europe member states, other countries can join the enlarged partial agreement and thus endorse the court and participate in various procedures. We're also looking forward to various logistical arrangements. The court needs a budget, it needs funding, it needs key personnel that will ensure day-to-day operation of the tribunal and good interaction with the ICC, state parties, national law enforcement authorities, etc. So these procedures are very important, and we hope that by the end of this year, hopefully, they will be in place.
You know, Ina brings up a good point here just very quickly you know, this, even though the Council of Europe has shown great leadership and courage to stand up to the rest of the world and a lot of strongmen around the world to actually do this, in reality, their procedures allow other nations to endorse and join the Special Tribunal. And so that will be happening, and it's not something that has to happen immediately and before the court actually is practically formed. But countries can join, and we saw this, Hans Irwin and I saw this in the Special Court for Sierra Leone. Countries can join in the capacity by which they would like to be involved. For example, China gave us office furniture. The Philippines gave us $5,000 a year. Canada gave us amazing, seconded to us Royal Canadian Mounted Police homicide investigators, et cetera, et cetera. So the support is not just political support, you know, saying this is a good thing, but it's also not just about money, but there can be other contributions that nations can get involved in as much as they politically want to be a part of. So I think this is important, even though it isn't centered in Europe, and perhaps now looking back on it, it's probably the correct place for it to be. In reality, the world can join and show strong men around the world that if you commit aggression, you're going to be held accountable. And that's really the historic moment that we are now in, is that Europe has stepped up by itself and said, no, aggression cannot be, you know, aggression has to be faced down, and this is how we're going to do it. So again, bottom line is this is not the perfect solution, but it is a solution that can be worked.
Great. And I think, and I'm going to start with you on this question too, which is also, I think, a little bit of a nuts and bolts question. But in terms of, so we know, having talked to this cohort in the past and various iterations of this as well, that investigations into crimes have basically been happening since the war started. Evidence has been gathered all along. How do you all anticipate the investigators and the legal teams navigating access to that and the credibility of that evidence? Was that part of the discussions of this as well?
Actually, this is the details that we don't know yet. We encourage good exchange of information and cooperation with various relevant authorities. What we do know that probably all the information and evidence collected by the International Center for the Prosecution of the Crime of Aggression, which was, excuse me, which was established by Eurojust, while the processes of establishment of the tribunal were ongoing. So now all this information hopefully should be passed on to the tribunal, and the tribunal should proceed with the processing this information and collecting further evidence. Also, we suspect that, because again, if we look at the statute of the tribunal, the cases will arrive from the Ukrainian prosecutor general. So the Ukrainian prosecutor general will make a decision which cases are to be submitted to the tribunal for prosecution and trial. So the cases will come from Ukrainian law enforcement authorities, and Ukrainian prosecutors and investigators accumulate evidence and data from various sources, including it's not only intelligence and military intelligence, but also whatever civil society organizations collect, open source intelligence, etc., etc. So there will be these various sources of evidence. We hope that there will be continuity of efforts and investigations and cooperation between various national partners and international partners, so that the efforts don't duplicate but complement each other. The bigger question here will be the admissibility of all the data, because we have at this point probably millions of pictures, video, and audio recordings that and witnesses' testimonies and other evidence that capture various crimes committed by the Russian Federation. And it's a great challenge for Ukrainian as well as international law enforcement authorities to process all this data to show clear chain of custody of the evidence collected and provide a consistent and comprehensive picture of what happened. Yeah, so this is the biggest challenge, and here again, various advanced IT technologies can be used. It's nice that international community supports Ukraine in prosecuting and investigating and prosecuting various crimes. So there's a lot of support.
If I may add here two things. First of all, many asked about the relationship between the Special Court and the International Criminal Court. And I think it's very important to emphasize that it's not a competition between them. It's actually the court that is now being established for Ukraine is a complementary court to the work that's done by the International Criminal Court. And the International Criminal Court has already issued indictments against the president and one of his collaborators for abducting children from Ukraine to Russia. There is already an indictment there. With respect to evidence, I would also like to refer to a system that International Bar Association has developed, where people can use their mobile phones to, shall we say, photograph or take up evidence that they can send to this system where it is protected, and it is then, shall we say, recorded from where and when the picture comes or the information comes. And this can be then used by courts in the future, both the International Criminal Court and by the Special Court for the Crime of Aggression. So I think it's very important to stress this complementarity. Thank you.
Yeah, thank you, Hans. Yes, David.
Just real quickly, Hans brings up an important point. Really, at the end of the day, we have three major centers of legal power that will be working with and going against Vladimir Putin and his henchmen. We've got the Prosecutor General of Ukraine working domestically, but then we'll be working closely with the prosecutor of the Special Tribunal. You have the International Criminal Court with its stature and its power, and then you now have the Special Tribunal. And so I look at this as an incredible opportunity, not one of competition, but collaboration, opportunity, working together to, in fact, at the end of the day, this is not about us. It's about the people of Ukraine and the tragedy that they have suffered. And so I was always reminding my people that work with me in West Africa that the reason we're here is to seek justice for the people of Sierra Leone. The same thing should apply at this level. It doesn't have to do with power and who's who and who's the chief prosecutor for what or what have you. It's about staying focused and working together to, in fact, achieve justice for the people of Ukraine and accountability for what Vladimir Putin has done to Ukraine. And with that kind of attitude, it's a powerful coalition of organizations arrayed against this aggressor.
I just want to mention, with regard to that coalition, the bar associations have played an important role here. The International Bar Association, New York State Bar Associations, so they've been important. And the judgment that Ina referred to today, the European Court of Human Rights, that also will be an important source at this point and repository, both for the investigative as well as the legal authority there. And what we're seeing, and this is what I think David has been properly prioritized, what would be seen as the coming together of what I would call a critical mass of engagement, of involvement in the pursuit of justice and accountability, of justice for the victims, and as I said, an accountability for the violators, and in this instance, the leadership crime.
It's interesting. This new tribunal will just be a star in a galaxy of stars that will be working together at so many levels, both diplomatically, politically, legally, practically, culturally, and looking forward to achieve justice. So you have to approach the establishment of the tribunal humbly. and realize that you are not the big dog in the valley, so to speak, but you are just a star in a large galaxy of very important players. And if you can assemble and get a consensus of working together, then it's amazing what can be done. We showed that in West Africa, and again, justice was done for the people of Sierra Leone.
We're actually getting a question as well as to what role did the New York State Bar Association, and I'm assuming it was probably the international section of the New York State Bar Association who was helpful in there, but what role did they play in this process?
Well, they were participants actually in one of the conferences that we had back in February on the issue of the tribunal. They were one of the conveners on that. They played an important role, in the run-up to the tribunal. There were a lot of actors involved, and I thought it was important to point out where you have professional bar associations that are engaged, as was the New York State one. And at the time, we were having meetings of the core group as well. There were tripartite meetings that took place in Riga and Vienna, and then there was a joint declaration of the core group, and then followed up by Brussels, and the New York chapter was engaged in that regard as well. So I think, as I said, it was a critical mass of participants coming together to make this possible.
Thank you.
Indeed, indeed. And I might add about the International Bar Association. I'm a member of the board there, that they have been very active. And Mark Ellis, the executive director of the International Bar Association, has visited Ukraine on several times and have very close contacts with the professionals in Ukraine who are dealing with this. So this is extremely important. And also, I mean, the crimes committed every day by Russia in Ukraine, it's absolutely unacceptable. It's not only the crime of aggression. We have also the Geneva Conventions and all these rules that are being violated, and systematic attacks against the civilian population and civilian targets. How can this happen in the 21st century? I thought we had learned the lesson from the Second World War. And we should respect the UN Charter. As I often say, we inherited the UN Charter from a generation that experienced 2 world wars. We should respect that heritage. And in particular, we should respect Article 2, Paragraph 4 in the Charter. Thank you.
Yeah, I might just add here that our Wallenberg Center for Human Rights produced one of the first reports on how the mass atrocities being committed by Putin and Russia were constitutive of acts of genocide. And so there are ongoing breaches of the genocide convention here. So what we see here is why we call the crime of aggression the supreme crime, the crime of crimes, is because it leads to all the other crimes, all the other mass atrocity crimes, including, as I said, the crime of genocide, but as Hans has mentioned, the horrific war crimes and crimes against humanity that are being committed as we are convening right now.
Ina?
I just wanted to contribute to what my colleagues said and to pay tribute to both the New York State Bar Association and the International Bar Association, because they both provided us, the Ukrainian bar, but also a wider legal community, with paramount support since the commencement of the full-fledged aggression. We launched a number of joint streams, starting from provision of pro bono legal support to Ukrainians displaced to various countries and residing abroad, to looking into international damages mechanisms and accountability mechanisms and collection of evidence, etc. The New York State Bar Association, as if I understand and remember correctly, was the first legal association in the world who openly and publicly supported the establishment of the International Tribunal for the crime, for the prosecution of the crime of aggression against Ukraine, which was soon thereafter followed by statements of the International Bar Association. And earlier this year, the New York State Bar Association also reiterated its calls from 2022 to support Ukraine, to ensure accountability for the international crimes committed in Ukraine. And we're very grateful for these and so many other efforts the international legal community undertakes to help us.
Thank you, Ina. David?
Well, let's not leave out our friends at the Ukraine Bar Association, which have steadfastly been the cornerstone by which we've been able to operate effectively within the boundaries of Ukraine, but also their important perspectives, both from a personal as well as a professional point of view, have been critical in the creation of many things, to include the Special Tribunal. Let me just go on another point that my colleagues have made. You know, Russia has and will not be able to win this war. They know it, but they have some capacity to destroy Ukraine. Just because they can't win, they will take it out on the people of Ukraine. And we saw that. We see this every day, as Hans said, every day, horrifically. Just the wanton firing of armed weapon systems into civilian populace just because they can, but they can't win. And so we have put together a task force in looking at the creation of a new crime against humanity and other inhumane act called mass destruction, where a nation state, as a matter of policy, realizes that it cannot win a conflict, but has the capacity to destroy, and in fact does so as a matter of state policy. And the perfect example is the Russian Federation. And so we'll be issuing a white paper on this new idea, which we will publish internationally, to cause a discussion by which then, under the other inhumane act statutes of various tribunals, to include the Rome Statute, one could consider what Russian Federation is doing is mass destruction.
Very interesting. I look forward to reading that white paper. I want to remind our audience that if they have questions, now is the time to start asking them, as we're moving into the last quarter of our discussion here. And I think I have sort of still one more nuts and bolts question before I move into some bigger picture questions. And I'm thinking it's safe to say that President Putin probably would not accept the jurisdiction of this tribunal. And so I'm wondering what that means for the tribunal, and how and whether that's more of a, I guess, a PR challenge, or more of an internal to the Russian Federation challenge, or if that really does present a challenge to the legitimacy of the tribunal. And Hans, I think I'm going to start with you on that question, just given your vast experience with all sorts of ad hoc tribunals.
Yeah, thank you very much. Well, I was aware that you would ask that question, and I was a judge before I came the legal counsel of the United Nations. So I looked at this question from that perspective, and I must say that I think that this very special question is important, but I think that let me say, could you repeat the element, the last?
Sure. So if President Putin doesn't accept the jurisdiction
Yes,
of this
exactly.
tribunal, yes, yeah.
Yeah, then my immediate reaction is that whether those indicted accept the jurisdiction of the court, that doesn't have any, shall we say, meaning. The question is what the judges of the court say. So when I was on the court, I'm sure that all those indicted before the court where I was judging, they didn't like the court one bit, but it was the prosecutor who decided to prosecute them before the court. And I think the same applies before an international court, that if the court is there, then if the court has jurisdiction over the crime, then it is the prosecutor who decides to prosecute, and then the court has to deal with the case. Thank you.
Thank
You
you,
know,
Hans.
just real quickly, President Charles Taylor argued the same point and lost. But the jurisprudence is against a sitting head of state who commits international crimes, and that's just a good example of all heads of state. And even if we look at going after heads of state or their henchmen related to aiding and abetting, they're going to obviously raise the very same question as they don't have jurisdiction and kind of blow it off. But that's not their decision to make.
Yeah, I think it's clear that Putin's not accepting the jurisdiction, it will not stop the prosecution. It will not stop the indictment. It will not stop the judgment. And so, in this sense, the pursuit of justice will go forward, regardless of whether he will try to stop it or not.
Thank you very much. We're getting a question from our audience as well as to whether the U.S. not being a signatory and even the shifting political priorities of the United States have presented some difficulty for this tribunal or for moving forward. Not sure who to start with there. David, I'll start with you.
Okay, kind of being the American on the panel, so to speak. The United States has been a partner in creating most of all of the significant tribunals from Nuremberg all the way through the International Criminal Court, and it plays a part mainly with a fairly open mind and trying to seek justice, but it also looks at these as how it can help American foreign policy and bolster American foreign policy and power around the world. So we just have to understand this is the political aspect of creating tribunals. You have to understand how each country approaches why they in fact support that tribunal. Currently, again, the U.S. is a member of the G7. Up in this time last summer, the U.S. is very much against the idea and is really very much against the idea of any tribunal having the capacity of prosecuting a sitting head of state. That's just a fundamental part of American foreign policy. They don't like it. That's not why they're part of the ICC, among other reasons, but that is a reason. And so they were very much against the idea in our statute that we put together and proffered to the working group is that they did not like the idea that we gave the special tribunal in personam jurisdiction over a sitting head of state and being able to prosecute them. And so that was a problem for it. So currently, at this point in time, the United States is really not a player. They pulled out of the working group. They have not, in fact, said much of anything about the process. But I think Europe is sending signals to the United States saying, we're going to go at this alone, whether you like it or not. And I think this is where the courage and the bravery of Europe coming together and other members of the core group saying, hey, it's a new world. Your go-it-alone approach to foreign policy, that's your prerogative. But at the end of the day, there are international standards which must be upheld, and we're going to uphold those. And so I think this is where also the moral victory is in the creation of the special tribunal, is that Europe and other members of the core group without the United States has stepped forward and created this thing. So far, the Trump administration has not really been a player and has not really been a problem. However, that's a lurking shadow on the horizon. And that's just something that's going to have to be dealt with. But again, it can be dealt with. It just depends on how much economic and political pressure the Trump administration decide to put against the Council of Europe and the Special Tribunal as it gets set up and it begins to start doing work. So I think there's going to be issues, but right now the U.S. is not creating problems for the creation of this tribunal.
I think.
Might I add? Sorry.
No, go ahead, Hans.
Go ahead, Hans.
Oh, all right. Well, I might just add, since I had a great experience with working with the Council of Europe when I was younger, and I was appearing before the court of the European Court of Human Rights as an agent of the Swedish government in those years. So I'm very pleased that they have actually acted in the Council of Europe. And as a European, I think that we have a great responsibility here. We simply must pursue this. And then there was a little technical element here. You said being signatory to the treaty, but a signatory does not bind in that sense. So you have to also, when you've signed the treaty, you have to ratify it, and then you become a party to the treaty. And this is very important, that this must happen with this court. Thank you.
Thank you.
Yeah.
Erwin?
The only thing I want to say is, I say this is a non-American clue, but I mean, President is mercurial, impulsive, a loose cannon, President Trump. And we saw the dressing down of Zelensky at one point, and the total inversion of fact and law, where for Trump at that moment, in that public humiliation moment, Zelensky was portrayed as the aggressor and Russia as the victim. So we might see these kinds of mercurial interruptions in the process, but I don't think it will affect or undermine the process, because the manner in which it has gone forward with such a concerted consensus and leadership, as I mentioned, all the various constituents of the Council of Europe and European Parliament, et cetera, let alone the core group. I think it's on solid ground, and that let's hope we'll have other states buy in. The one thing that does, cause me some concern, I've mentioned before, is that it should not be characterized as being Euro-centric, and that the global South then, through the BRICS group, et cetera, becomes another actor that might seek to undermine it. So I think in that sense, we have to be aware and make it as representative as possible for buy-in by other states in the management committee, in the formation of the court itself, et cetera.
Once it becomes a legal entity, there's nothing that the Trump administration can do to stop it. I mean, that's why we were so concerned about creating this in 2025, is once it's there, no one can stop a tribunal. In other words, it is now an entity in and of itself, and that no outside influence can stop it. And I think this is really, really important. Granted, there can be pressures, but the actual idea and the actual court itself cannot, Trump can't stop it. He has no standing to stop it. And so that's why it was so critical, and that's why this is so important today that we have created it. And so it's now a legal entity in and of itself, and it will do its mandate according to law.
Thank you. All right, I think I have time for one more question. I guess that might depend on how fast you all answer this question, but I'm curious to what does the standing up of this tribunal say about the future of international justice? Is there something we can take away from it? I'm not sure whether it's how long it took to get this stood up, or maybe Europe's new role or new courage in this. Not that they haven't been courageous all along. I don't mean to imply that. But I'm just curious as to what does this signal about the future of international justice? And Erwin, I think I'm going to start with you on that one.
Well, I think the most important thing here is combating that ongoing culture of impunity that I referenced. And the most important statement it makes here is about accountability. And with regard to accountability, that no one is above the law, and that the crime of crimes, the supreme crime of aggression, the leadership crime, those involved in will be held accountable. And David Crane made an important point. Let us not forget the aiding and abetting part, because I think those that have been aiding and abetting Russia in its crime of aggression also have to be held accountable.
Thank you. Anybody have anything they'd like to add to that?
Well, if I may add just that I'm very worried about the situation in the world today. During my 10 years as legal counsel at UN, between 1994 and 2004, 3 years at Boutros Ghali and 7 years at Kofi Annan, there was a rather positive development. And then it all started going the wrong way. And I'm extremely concerned now about the situation in the world. And I have met Mr. Trump before I became president, and I wasn't really sure that he was a candidate that should be elected. So I was rather surprised when I saw the result, and that he was also then re-elected. I'm a Swede, but I'm a member of American Bar Association. You can be that without being an advocate. And a few days ago, I received from the president of the American Bar Association a letter dated the 3rd of March this year. And it was an extremely critical letter of the present administration in the United States of America. And he asked every lawyer being member of the American Bar Association to raise these matters and to work for a better future here. So I think it's very important. And for the rule of law, I have been working for this since I retired specifically. And I might add here that there is now available on the web a guide for politicians on the rule of law, and it's available in 26 languages. Soon 27 will come. It's just to Google the words rule of law, a guide for politicians, rule of law, a guide for politicians, and you will find it. And it doesn't cost anything. It is some 40 pages, and it is available, as I said, in 27 languages. So I make just this comment as stressing the importance of that politicians understand their responsibility for the rule of law. And who taught me
Yes,
that
thank
lesson?
you. We'll
Helmut
also link
Schmidt.
to that document.
Helmut Schmidt of Germany was the one who said these words that gave me the idea of publishing this short, brief guide. Thank you.
Thank you, Hans. Yes, we'll also make sure to link that in here because it is certainly a valuable read. You have referenced that for our audience in the past, and it's certainly well taken here as well. Well, I want to be respectful of our lunch and learn time. So thank you so very much, David and Hans and Ina and Erwin, for joining us today for this conversation and for imparting your wisdom with our audience. I will also take this time to mention that if you are interested in the programming of the Robert H. Jackson Center, please visit our website, roberthjackson.org. You can see all about our events and get more involved with us as well. Thank you to our audience for joining us today, and thank you all so very much.
Thank you.
Thank you.
Thank you.
Bye.
Thank you.